The next case to come before the court is Bank of America versus John Edwards. Good morning.
Good morning.
I have all kind of different times going here, so it is a few minutes early. Is it okay to proceed, or are you waiting for anyone? Or?
From Bank of America side, we're ready, Your Honor.
We're ready.
Thank you. Thank you. Well, each side will have 15 minutes to present their arguments, and the original appellant may have up to 5 minutes for rebuttal.
Good morning. May it please the court. My name is Josh Lamb. I represent John and Stacy Edwards. This matter is in connection with a foreclosure action that was filed with the Lorain County Court of Common Pleas by Bank of America against John and Stacy Edwards. There are essentially three main issues here before the court. The first issue is to whether, regarding standing, as to whether the trial court erred when it determined that Bank of America had standing to pursue the foreclosure. The second issue is dealing more so with Bank of America's assignment of error, and it deals essentially with the face-to-face meeting requirements for an FHA loan, and whether the trial court erred in determining and dismissing the case with prejudice on that basis. The third issue results in a clerical error so much in the trial court's order when it issued an order saying that it was on the merits and then turned around and said it was without prejudice. As to the standing issue, it's the Edwards' position that the trial court erred when the court found that it had standing to pursue the case. In this case, Bank of America claims that it has standing to enforce the note based on a merger that occurred, or allegedly occurred, between Countrywide Bank, FSB, into Bank of America. The note itself was based on, it was originally endorsed to Countrywide Bank, FSB, and then it was signed or endorsed in blank by Bank of America as successor by merger. But in the motion for summary judgment and related documents, Bank of America does not submit the merger documentation or any other relevant documentation proving that merger. Instead, what they do is they submit an affidavit that says essentially that they merged, and they file or submit a what they call an institutional history, which is essentially a printout from a website from the National Information Center, which supposedly is or purportedly to suggest that these two companies merged. It's our allegation or assertion that this is not sufficient evidence for standing. We believe, and I can point to the case PNC Bank versus West, which is cited in our briefs, that they require to include the actual merger documents from their business records to prove that standing exists. And if they can't provide some sort of certified copy from the state agency, public agency, whatever it is that has those records, then they're supposed to, in their affidavit, state that they've compared those documents to the originals and that they're one and the same. In this case, I mean, like I said, all we have is a website printout. That's not a business record of Bank of America. It's not actually a record of Bank of America. It's not maintained by them. It's from a third party. That third party did not verify, certify, or has any official seal or anything of that nature certifying that that was correct or accurate. And I think, in fact, in the affidavit for Bank of America that they submitted, I only believe that they state officially that it's a true and accurate copy of that record. It just says it's a copy of the institutional history. I believe the trial court, in discussing this issue, essentially said they eventually reviewed the case of Wells Fargo Bank versus Horn. And in that decision, and it was Ohio Supreme Court decision that was recently decided, that court decided essentially that there is an issue as to when standing should be determined. Not so much how standing is determined. And in this case, and I would point out in that case, there was actually certified merger documentation submitted to the court. That doesn't exist here. And I think the trial court just said, well, there's more details in that case, or less details in that case than there were in this case. I don't think it really addressed the specifics as to whether merger documentation should be submitted or not, but I think the law is clear that that has to be submitted. And I don't think a website printout from a third party is a basis for establishing standing for that merger. I would also point out that the affidavit submitted, there were 2 affidavits submitted by Bank of America in this case, and they're inconsistent. The first one argues that there was a merger between Countrywide Bank, FSB, Federal Savings Bank, and Bank of America. The second one states that there was a merger between Countrywide Bank National Association and Bank of America. 2 completely different types of legal entities. There's nothing in the record that really states why this was different. The note itself states that it was originally in Countrywide Bank FSB's name. I think that inconsistency creates an issue as to whether standing is appropriate here. As to the second issue, in regards to the face-to-face meeting requirements, the trial court issued an order that dismissed the case with prejudice on the grounds that Bank of America did not comply with the FHA loan requirements when it comes to face-to-face meetings. Essentially, Title 24, Section 203.604 of the Code of Federal Regulations requires an FHA lender, before they can accelerate a loan and before they can file a foreclosure action, they must do one of 2 things. They either need to have a face-to-face meeting with the homeowners within, I think, 3 months of the payments being unpaid. Or if they can't do that, they have to make a reasonable effort to have that meeting within 3 months. Here, there's no dispute that that meeting never occurred. So the issue comes down to whether there was a reasonable effort made by Bank of America. Now, the rule specifically states what is a reasonable effort, and it requires 2 things within this 3-month period. First, there must be a certified letter sent to the homeowners requesting the meeting. Second, they have to take a trip out to the mortgaged property and try and have that meeting. In this situation, none of that occurred. What happened is, especially within that 3-month period, what had happened is that Bank of America is stating that the loan defaulted in August of 2009. 2 years later, believe in September of 2011, they sent a letter, or had a company affiliated with them send a letter asking for that meeting, well beyond the 3-month period that we were required to send them. It was also not sent certified mail. That's not disputed in the record, and the statute specifically, or the regulation specifically requires that be sent by certified mail. And I believe there's a case, Liberty Savings versus Bowie, that says that's the minimum standard. You have to send it certified. That wasn't done here.
Counsel, I will have you come back to that if you
Sure.
want, but I can't get past something, and it's this. The plaintiff filed a motion for summary judgment. You filed a brief in opposition to that. There was a reply and a surreply. Those are what the trial court indicated it considered in issuing its rule. Did you ever file a motion for summary judgment?
There was not I'd say a formal motion for summary judgment. I believe in our responses
That
we did.
answers
Okay.
my question.
Okay.
Did you ever file a motion to dismiss the case?
I think the court did that on its own based on the facts of the case. I mean, I think
How does the court have authority to do that?
You've
You've just made a lot of arguments why their motion for summary judgment shouldn't have been granted. What authority does the trial court have to say, hey, I looked at this, and not only am I not going to grant their motion for summary judgment, I'm going to dismiss this case outright, even though nobody's asked me to?
I don't know that I have a case off the top of my head, Your Honor, but I would argue that based on looking at the facts, I think that the court would have the authority to look at it and say, there's nothing that they can prove here. There's no set of facts that beyond any type of, there's nothing that they can prove that would ever amount to any type of claim.
But they're not trying to defend the motion to dismiss, or they're not trying to defend the motion for summary judgment. They're seeking judgment in their favor. How appropriate is it to grant essentially summary judgment when you didn't even ask for it?
Well, Your Honor, like I said, I guess in the body of the document, we asked that the case be dismissed. Like I said, there was no separate formal motion. There was no caption that said motion to dismiss, motion for default judgment. But our response did request that there would be a dismissal based on those facts.
That doesn't trigger all of the Rule 56 guarantees, procedurally. I don't think, by just mentioning it in your reply.
I understand that, Your Honor.
And that goes to their fourth issue for review, I guess, and that's the part I'm having trouble getting by. I've just never seen it before.
Okay. Yeah, and like I said, I think my position is that essentially, if they're, I think just based on just the plain face and meaning of the documents and the evidence that is submitted, I mean, I would argue that a court has the right to just dismiss the case because just based on the face of those documents, that there's nothing that they can do or prove that would ever amount to any type of claim. I guess going back to that FHA issue,
You're at 5 minutes now. Do you want to reserve time?
I have 5 minutes left, Your Honor. Could I just request 2 minutes?
Oh, sure.
As to the FHA issue, the Bank of America has essentially made the argument that the rule is aspirational. It's not really a rule. It's just something that we should try, and it's not fair. It wouldn't be fair to enforce that order if because essentially they'd never be able to foreclose. But if you look at the rule, it includes the language. It must have a face-to-face interview. It shall send a certified letter. It shall travel to the property. And those are mandatory terms. And I mean, there's nothing in the rules itself that suggests that it's discretionary or that that shouldn't be enforced based on its actual meaning. And we're talking about a note and a mortgage. We're talking about a contract. And these are terms. We're just asking that those terms be enforced the way they were written. I think the only issue as to this, I think the Bank of America makes an argument that this issue wasn't stated with specificity in the answer. I would disagree with this. I think the trial court disagreed with this. I would point the court to Wells Fargo versus Miyake. That's how I pronounce it. And in that case, they stated that failure to give proper and requisite notices to defendants pursuant to the note and mortgage, pursuant to federal regulations, was sufficient to put the parties on notice of this defense. In this case, Bank of America argued the issue from this motion for summary judgment from the beginning. I think there was notice here. I think Bank of America, they will argue that we should be required to say directly say this is an FHA loan in the answer, or that we should have to say that what specific statute or regulation that we're talking about here. But the cases don't say that, they don't require that. I mean, I think the documents speak for themselves that this is an FHA loan. If the note and the mortgage say this is an FHA loan, I don't think doing that in an answer is going to help anything, put them in any more notice than it is. So, Your Honor, looking at this, I mean, as the only other final issue would be the clarification issue. The court accidentally or incidentally issued an order that said it was on the merits but without prejudice. On the merits is with prejudice. Not on the merits is without prejudice. And I point to a customized solutions case that I cite in my brief for that purpose. Here they tried to issue a non-pro-tunc order, but it was filed one day after the notice of appeal, arguably divesting the court of that jurisdiction to issue that order. We would just request that the dismissal be confirmed, that it was a dismissal with prejudice based on Bank of America's failure to comply with the FHA guidelines. Thank you.
Good morning.
Good morning, Your Honors. May it please the Court, Jason Whitaker on behalf of Bank of America, the cross appellant. Your Honor, we believe that the trial court made both procedural and substantive errors in its decisions that should be reversed by this court. The procedural issues are significant. First of all, I do believe that this court's own case authority points to a suggestion that the defendants waived the defense of whether that particular regulation was complied with. I'm not sure how the defendant's argument differs from the argument that's made in the Onawala case that we cited in our brief. And in that case, which this court decided, the defendant had specifically pled that the plaintiff failed to comply with one regulation and then sought to argue a different regulation under the same scheme of regulations at the time the summary judgment was pled. This court said to Mr. Adewale, you waived that right to defend. Other cases that we cited from the 7th Appellate District, Garland and Miller, have also said that a defendant who pleads generally that the plaintiff failed to comply with HUD regulations is not sufficient to put the plaintiff on notice that they're making a specific defense. The defendants in their answer here, unlike the Niamki defendants who specifically pled a failure to proceed, that the bank failed to prove that it had complied with federal regulations, these defendants don't mention federal regulations at all in their defense. What they say in their affirmative defenses are that the plaintiff failed to comply with the applicable servicing guidelines. Well, a number of Ohio courts have already made a distinction between servicing guidelines, which generally are known as, I think the Carpenter case out of the 2nd District went into, are Fannie Mae servicing guidelines or investor servicing guidelines, and federal regulations. For instance, in the Carpenter case, the defendants had alleged that they could assert as an affirmative defense to foreclosure a failure to file Fannie Mae's loss mitigation servicing guidelines. And what that court said was that itself is not an affirmative defense because the servicing guidelines of an investor or a government-sponsored enterprise do not have enforcement effect of law as a federal regulation. So there is a difference between them. And I think this bleeds into the second procedural error that the court made that Judge Cannon has already pointed out, which is the court essentially granted summary judgment to someone who didn't seek summary judgment. And while I respect the argument that counsel made in response to that inquiry, I think looking at it as a whole, when a party moves for summary judgment, all the factual issues in the case are construed most favorably to the non-moving party. And so the only party that moved for summary judgment here was Bank of America. And so when the trial court looked at the evidence before it, it construed the evidence most favorably in favor of the non-moving party, the Edwards. Had the Edwards themselves moved for summary judgment, all factual inferences would have been made in favor of Bank of America. And Bank of America would have been put specifically on notice as to what those claims were. What we had here is an answer that didn't quite comport with what it needed to comport with in terms of the rules of civil procedure, because under those rules, when a plaintiff generally avers that it satisfies all conditions preceding to a civil action, under the rule, the burden then shifts the defendant to not only assert that conditions preceding weren't satisfied, but to identify them specifically one by one. The fact that the contract says one thing or another is sort of irrelevant as to whether or not the defenses are waived. The substantive issues that I think the trial court made, or that Bank of America asserts that the trial court made, were first finding that instead of simply finding that Bank of America did not prove that it sent a letter in conformance by certified mail in conformance with 203-604D, it said there is no evidence as to how that was sent. And I think that Bank of America would concede that the evidence before the trial court is somewhat fuzzy as to how that was sent. And perhaps as the moving party on summary judgment, the court could infer that the plaintiff was not entitled to summary judgment because it did not prove that that letter was sent by certified mail. I think it used other language in there, did not say what method it was sent, it just said that it was sent. The other substantive issue that the trial court set out was, although the trial court acknowledged all of the case law in Ohio and elsewhere that the plaintiff cited, that Bank of America cited, showing that compliance with these regulations is the time frame compliance is aspirational, the trial court acknowledged all of that and then said, essentially, we're not going to look at that language, and we're going to say without any kind of authority, without any kind of real backing, that we're going to hold the plaintiff to strict compliance. So the trial court essentially said that even though the defendants don't challenge their default, they don't challenge their failure to pay, they don't challenge their breach of the contract, that a foreclosing entity, a servicer, can perhaps never foreclose on them unless it somehow modifies the loan. And I'm not sure what sort of impetus a defendant in this position would have to modify a loan at this point if they can't be pursued. The other thing I think the trial court did substantively wrong is it reiterated that a foreclosure, its case itself was it was an equitable remedy in which the trial court had to balance the remedies, and they said, well, the lender takes the benefit of taking out an FHA loan, and so therefore you're stuck with strict compliance. While maybe that in some respects is true, that the lender did issue an FHA loan, the borrower in those instances also get an FHA loan, which allows them to purchase a property like this one without putting the normal amount of down payment. They get a number of benefits for taking out an FHA mortgage, and so both sides jointly are involved in this FHA transaction. And I would argue, or Bank of America rather would argue, that the trial court committed errors both procedurally and substantively. And I think looking at both this court's precedent and the precedent of this court's sister districts, this would suggest that the defendants waived the right to this defense, that the defendants did not themselves seek summary judgment, they did not seek dismissal, and in fact gained the benefit of being the non-moving party, because in the context of the evidence before it, the trial court construed every piece of evidence most favorably in their favor. So this wasn't a trial on the merits, and I don't believe that the trial court has the authority without notice to dismiss a matter with prejudice. I think that law is clear. There's no citation to the contrary. It's really not asserted directly in the briefs. But what we have here then is if the defendant's response to a plaintiff's motion for summary judgment, or really any party's response to someone else's motion for summary judgment, by asking that that summary judgment be dismissed, it somehow gives the trial court the unilateral, sort of on its own authority to dismiss a case without prejudice, without notice that it's going to do so, would violate long-standing law of the Ohio Supreme Court.
What's not specifically addressed in the brief?
There's no, Your Honor, to my knowledge, there's no specific assignment of error by either appellant that the trial court had the authority to dismiss a case with prejudice, without notice, to the party being dismissed.
So what are we to do with that? Because I was wondering about that. I'm glad you raised it.
Your Honor, I think from the...
Isn't that your burden to do an appeal to demonstrate error, and if you don't raise that issue?
Your Honor, I'm not raising the issue that the plaintiff, or sorry, the cross appellant certainly raised the issue that the trial court has no authority
To do the non-pro-tunk.
to not only to do a non-pro-tunk, but to award summary judgment to a party that did not move for it. And in fact, in our brief, we did cite Supreme Court authority in support of that position. And there's no contrary authority that I can find. I don't believe it's the cross appellant's duty to sort of assert the reverse, that the trial court sort of did something different. I think...
Yeah, I'm not sure I'm understanding. I apologize. It's probably me.
No, you could sort of flip sort of two sides of the same coin. I believe we preserve the error and argue that the defendant was not entitled to summary judgment, which essentially what the defendant received was an order granting them summary judgment, because they received an adjudication on the merits, arguably. That's one side of it. The other side is the defendants are essentially now arguing for the first time in the court that the trial court does have the authority to grant them summary judgment without so having moved. I think that's the flip side of that argument, that the defendant, that the appellants would have had the burden to preserve, which is that the trial court did in fact have authority to grant summary judgment to them.
Well, if we take the proposition that that's in essence what the trial court did, and I apologize, I always point my pencil at people, so I'm going to put my hands down. If the trial court had, in essence, did do that, he doesn't care, does he? Shouldn't you be the one to care?
Well, I do. The Bank of America does care, Your Honor, and we did raise a specific assignment of error to that effect.
About the non-pro-tunk, and they did have the right to change that.
Well, not only that they did not have a right to issue a non-pro-tunk entry, but that they did not have the trial court did not have a right to grant summary judgment to a non-moving party. that's essentially part and parcel to our fourth assignment of error.
Okay, I just didn't necessarily see it the same way you were seeing it.
And I apologize. Your Honor.
No.
This is one
Like
of,
I said, probably me.
it's one of a few cases that I've been involved with where there are 5 briefs on each side. Total of 5
It
briefs.
gets confusing, I agree.
So I think.
It's actually not assigned as error. It's your fourth issue presented for review, but the error that's assigned is with regard, the first error that's assigned is with respect to the non-proton entry. And the second error that's assigned is just, you shouldn't have granted summary judgment for Edwards for the reasons that you state there, not because the trial court didn't have authority to do it.
Your Honor, and
I think, I don't know if that's, but.
No, I just.
Your fourth issue
I just
presented.
wasn't making myself clear, and I wasn't sure I was
Well,
understanding
it's not
clearly
very clear.
enough.
It's not very clear.
Your Honor, we would argue that by arguing that the trial court erred in granting summary judgment to the Edwards, that encompasses that issue and preserves the issue. Because the trial court's entry says nothing directly about granting summary judgment. And I think that goes back to an area of fairness and litigation of all the parties. When I'm defending a motion for summary judgment, I act differently than when I'm simply asserting a reply in support of my motion for summary judgment. Again, I think it all goes to the burden of proof and the way, the scope of the way the evidence is reviewed. When the evidence in the case is reviewed in the sense that I'm construing as the trial court all of the evidence most favorably to the non-moving party, the non-moving party can't simply then sort of backdoor ask for summary judgment in their favor. The trial court can't grant summary judgment in their favor because then they violate the rule.
But we're not talking about a material dispute of fact here, are we? We're not talking about any dispute of fact here, are we?
Your Honor, I think the dispute of fact, to the extent that there is a dispute of fact, is that the trial court, the appellants have asserted that the trial court found that the letter was not sent by certified mail in conformance with the statute, that it was sent, that there's a question of timeliness and time frame, but in terms of whether it was sent by certified mail or not, I don't believe the trial court actually said, we find that the letter was not sent by certified mail. What the trial court says is that the plaintiff did not prove in its motion for summary judgment that it was sent by certified mail. And again, when they're construing the evidence most favorably in favor of the non-moving party, I would concede that the question's a little murky. And so I would say that how that letter was sent, the method that letter was sent, is in fact in dispute. Because the plaintiff is saying it was sent in compliance with the statute, the defendant's saying you didn't prove by certified mail. The trial court agreed with them. And I guess in the context of denying the motion for summary judgment, I could understand that. But then denying the motion for summary judgment and then saying that the plaintiff doesn't have the right to get a trial on the merits is a much different argument. And we would just ask this court to remand the decision back. And although it would be ideal if the court were to reverse and grant summary judgment in favor of the plaintiff and the cross appellant, certainly I believe it's proper that the matter be reversed and set for trial, remanded and set for proceedings consistent with that opinion, which would be that both sides get a chance to get a trial on the merits. The interesting flip side of this is that the defendants are arguing that the court erred in not dismissing the case for lack of standing, which would be an interesting procedural change to the case because if the plaintiff never invoked the standing of the court, does the trial court have authority to render a decision on the merits in that case? And so if the defendant's own assignment of error is adopted by this court, essentially this court, although I would think that the Ohio Supreme Court has said that there's no lack of subject matter jurisdiction, but what they say there is that the plaintiff failed to invoke that jurisdiction. And if that's the case, then everything that we went through in front of the trial court probably sort of vanishes into thin air, and I guess we get to do that all over again.
And you're out.
Thank you.
Thank you.
Thank you, Your Honor.
And please report. Addressing some of those issues raised by Bank of America's counsel. As to, I understand, we filed an assignment of error as to standing, which could potentially create an issue. I don't think I can just waive arguments on behalf of my client. I understand that there's that potential issue that, hey, maybe the the case gets dismissed based on a standing issue and we have to start all over again. I understand that, but I also believe that, you know, you just can't just waive an argument of a client, regardless of what could happen, what might happen. As to the certified mail issue, I would take the opinion that there is not a material issue of fact as to that issue. I believe my client submitted an affidavit stating something along the lines of, and he never received any type of certified mailing or any other type of document from them. That was never disputed, or and I believe Bank of America has admitted that although they sent a letter, that issue was never disputed that there was sent certified by my client. As to why the trial court dismissed it on those grounds, I don't know if it was so much because it wasn't sent by certified mail. I believe the trial court said it was not sent within that 3-month time period. And that's in the record. That was admitted by Bank of America. It was sent a few years after the fact. And because of that, I think the trial court said there's no way that they can go back in time and fix that issue. And because of that, they had to dismiss the case because there's no set of facts that they could prove that would show that they've complied with those documents, with that requirement. And again, as the aspirational issue, I know that Bank of America has cited, I think, the 5th District, 7th District cases. There's no case by this court that's ever addressed that issue as far as I'm aware. And as far as that issue, all we're asking is that the rule as written be enforced. To just argue that it's aspirational, I mean, to me, that argument can be made for any obligation under the note and mortgage then. I mean, could I make the argument that my client's obligation to obtain homeowner's insurance or pay on the note is aspirational?
And you're out of time.
Thank you.
Thank you to both sides for presenting your arguments to the court. The court will take the matter under advisement. We will issue a written opinion that will be sent to both sides as well as released on the website. Thank you.
Thank you.
Thank you.